name is Bridget Mackay, and this next series of blogs I'm doing for my video blogs off of my website is on same-sex relationships and estate planning. I'm not going to talk a lot about Prop 8 or any of the politics around it. I really want to address some really basic issues that I think same-sex couples need to think about going forward in their relationships and planning for their futures. The first subject I'm going to talk about is sort of how do you define your relationship? Because of Prop 8 and the legal wranglings over defining relationships in this state, there has emerged many different layers of relationship qualifications for same-sex couples. The first is, the standard not married, not a registered domestic partner, but you're living together and perhaps have had a long-term relationship or even a short-term serious relationship, but you hold yourself out and you live together as if you are a married couple, but you have no legal binds to that the state of California offers. The next step up from that is what we call registered domestic partnerships, which are different, I think, than domestic partnerships, which have been defined for also opposite-sex couples. But for same-sex couples, the only people who can register with the state of California are as a domestic partnership are same-sex couples or couples where one of the partners is over 65 years old. That is another level of relationship. When you move into this realm, there are some rights and responsibilities that come with it. The state of California treats these relationships as if they're married couples. So if there was a divorce, then all the property that was acquired during the union or the registration is considered community property, and all the responsibilities for the other spouse or the other partner in the relationship attach. In an estate planning context, if you are a registered domestic partner and one of your spouses or your partner dies, you as the surviving partner are afforded all the rights as if a spouse would be under California probate code. So you would inherit everything from your domestic partner, depending on if that domestic partner had children. You would inherit a fraction, if not all, of their estate. The next is married same-sex couples, and that was only a window of time where it was considered legal. And the law's much grayer in this area. When I'm talking about how the laws apply, I'm talking about California probate laws. Tax laws are a whole different ballgame. The federal tax, or the IRS, has never recognized same-sex couples. And so, unfortunately, those couples suffer some more harsh tax consequences than opposite-sex couples. But married same-sex couples essentially are in a similar registered domestic partnership realm for the time they were married, but once the laws were repealed and are in the process of being appealed, they stand in a much more tenuous spot. So as you can see, it's very important for you to identify what your status is, because it will help you moving forward to plan your estate plan. And the most important, I think, in fact, the people who need estate planning the most, I believe, are often same-sex couples, because there is often many dynamics and also such a difficulty for our society to recognize these couples. And so they face a lot more legal barriers in planning for their future. So please stay tuned for our other videos. If you are working with an attorney now, make sure that they understand these different relationship variations and are planning for your future successfully.